Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5035. Lori Panarello, appellant, versus Debra A. Haaland, Secretary, United States Department of the Interior. Ms. Bertrand for the appellant, Mr. DeGennaro for the appellant.
Good
All
morning.
right, Ms. Bertrand, good morning. Please proceed.
Good morning. My name is Joy Bertrand, and I represent the plaintiff appellant, Lori Panarello. This case presents an opportunity for this circuit to join the 11th and 7th circuits in finding that the resolution of adverse employment actions contingent on withdrawal of protected Title VII actions is evidence of retaliation. Knox versus Roper, cited in the appellant's reply brief at 17, talks about a similar circumstance to what happened with Ms. Panarello.
Well, let me interrupt you because this is the only issue that I see in this case. And I have combed the record and I see nowhere where a decision maker, not Peyton Williams, who is not a decision maker, but where a decision maker, that would be Fear, or his agent who was delivering the termination notice, ever mentioned the last chance agreement. It was Peyton Williams who said to Fear, will you consider it? He said yes. He obviously didn't consider it because Libby delivered this termination notice. Your client asked if it could go to the end of the pay period. He called Peyton Williams and she told your client, well, you were supposed to be offered the last chance agreement. And she said, I'm not interested in that, or whatever she said. The offer was never made, as far as I can see from this record, by a decision maker. Peyton Williams was discussing it, but where did a decision maker ever relay that to your client? And even your client in her depositions doesn't say that.
Your Honor, Peyton Williams works at the behest of the decision maker. She worked directly with the decision maker.
She's human resources. She has no authority, as far as I can tell, and she even said she didn't, to make the decision. And that's clear from her actions. She said to Fear, will you consider this?
Your Honor, I believe the government agrees that this was extended to Ms. Panarello.
And I think the district court agrees, and I think they're all wrong on this record.
But it's not, the thing is, at this point, we have this discussion of it, and at the summary judgment stage, that is, if Your Honor believes that that is something that hasn't been entirely established, then that is an issue of fact for a jury, especially when the government hasn't contested that it occurred and that Ms. Panarello was given that last chance offer and rejected it because it was based only on the withdrawal of the pending lawsuit.
All right, well, let's talk about what the district court said. The district court said it came too late. The decision had already been made. That is clear from the record. The termination notice was delivered by Libby. Your client asked for more time. Libby calls Peyton Williams. She says, you were supposed to be offered this, and she says, I'm not interested. And that makes it too late, even if we assume it was offered at that point.
I respectfully think that it wasn't too late. And this is what happened in Roper, or Knox versus Roper, where the decision was made and then the employer came back and said, well, we've decided to fire you. However, if you don't want to be fired, withdraw your pending protected EEO matter. And here, the same thing happened, that yes, the firing decision had been made. And this is, for example, here's
But the offer was made by someone who had no authority to make the offer. If that's what if what Peyton Williams said was an offer, she has no authority to make that.
Your Honor, I don't think there's been any factual finding in the lower court confirming that Ms. Peyton Williams did not have the ability.
Well, in her deposition or affidavit, she says she doesn't. Well, you go on with your argument, because I'm taking up a lot of your time.
Sure, thank you. There's an analogy to this that I would ask the court to consider, and that would be this. If you had an employee who had a pending Title VII matter, whether it was like an EEO complaint or an actual lawsuit, as we had here, and that employee comes in late to work several times, and the employer says to her, "We're going to fire you because you've been consistently late to work. We've decided to fire you." And then the supervisor or whomever, HR, and there's been no indication in this record that Peyton Williams doesn't have the ability to communicate decisions from higher ups, and the government has agreed that this was extended to Ms. Panarello. If the employer comes back and says, "Well, we did decide to fire you. However, if you have sex with me, your boss will drop the lawsuit." And this is, or will drop the firing. It would be the same type of quid pro quo as we have here. We've decided to fire you. We're holding your job hostage, but drop your lawsuit. And what's really—
It's not the same though, counsel. I don't think that analogy works. I mean, global settlements, I mean, I don't know what the latest data is, but, it's something, very well north of 90% of civil cases get resolved by settlements. And global settlements are the preferred way to do it. I mean, it's malpractice for a lawyer to settle one case, and if the same party has a different case pending against their client, to try to figure out how to make them both go away. And so I don't think that you're comparing apples and oranges here. And so to me, I don't think that analogy works. In the way that your retaliation theory has to work, really has to be that they didn't really have any intentions on really firing her at all when they proposed it. Instead, they proposed it so that they could get her to settle a separate lawsuit that she had brought, by proposing this kind of without really meaning to follow through on it, to see if she would be kind of pressured into agreeing to a last chance agreement. I mean, that's the way your theory has to work, right?
Well, Your Honor, I agree with the court that global settlements are always preferred. And one thing that I think is important that the court just noted here is that it would be lawyers do have an obligation to try to resolve as many issues as possible, but here the lawyers were never presented with this, and they didn't have an opportunity to negotiate. And what Knox versus Roper says in the 11th Circuit is, no, you can't create this kind of contingency, especially on a case that's not related to the discipline at issue. And here, in addition to that, we don't have anything in the record about there being any other contingencies regarding this last chance agreement. Ordinarily, as the court is well aware, and as we see frequently with last chance agreements, there's a performance plan put in place. There's things the employer has to do, but things the employee has to do to improve their performance. There was never an issue with Ms. Panarello's performance. And in fact, she stayed working throughout this. She had access to confidential information. She was receiving briefings. She was mentoring subordinates. So there was no performance to be improved upon. The only contingency discussed in this last chance agreement idea that was relayed to Ms. Panarello was that she drop her pending lawsuit against the agency. And that's what Knox versus Roper and to a related extent, the Coggins decision out of the Seventh Circuit says you cannot do. There is an issue of fact here about whether or not, but for the employee rejecting the term that they drop their Title VII action, they would have been fired. I'm sensitive to time, Your Honor, and I'm at 20 seconds. So I want to make sure that the court doesn't have any other questions for me before Mr. DeGennaro.
All right. Judge Rogers, do you have any questions?
No.
Okay, well, we'll give you a couple minutes and reply then. Thank you.
Thank you.
Mr. DeGennaro.
Good morning, Your Honors. Assistant United States Attorney Stephen DeGennaro on behalf of the appellee. I would like to begin briefly on this question about the last chance agreement that this court earlier asked about and highlight an additional reason to reject Ms. Panarello's last chance agreement argument beyond that which Judge Henderson had identified. And that is these preliminary global settlement discussions between a human resource official acting at the behest of the deciding official and Ms. Panarello to explore the possibility of a global settlement is not at all dissimilar from global settlement discussions generally, but for the circumstances that in which it came out. And our position would be that this puts the case more in line with the line of authority mentioned in the case that was cited in the Secretary's brief, Snowden versus Zinke, a decision by then Judge Ketanji Brown Jackson that discussed how courts within this circuit and elsewhere have upheld knowing and voluntary waivers of then existing Title VII claims as part of a last chance agreement. There's also evidence in the record that the Park Police had not only offered last chance agreements previously to other employees to waive then existing Title VII claims, but that—
Where do you think in the record it is apparent that she was made an offer by someone in a position to make her that offer?
Your Honor, I believe that there was testimony during Ms. Payton's deposition that she had asked Deputy Chief Fear to consider the last chance agreement.
And he said he would. And
Yes.
The next thing we know, she gets a letter of termination. He obviously decided to consider it and reject it from the record.
Yes, I believe that is generally the sequence. It was after the decision had been, the decision on removal had been tendered. Ms. Payton then asked Deputy Chief Fear whether he would consider the last chance agreement. But the government's argument is even—
No.
You know,
Oh, you mean Payton? Well, Payton
Yeah, Ms.
Williams. Okay. Now,
yes.
I get the feeling that, no, you're right, because she said she had that, she said she had the discussion with Panarello on September 9th. And that had to have been when Libby calls her to say, can she extend the termination to the end of the pay period? And Payton Williams says, well, she was supposed to be given this offer. That's her testimony as to when she tells Payton Williams about it.
Yes, that is my recollection as well, Your Honor.
Okay, so I'm still back at who made her the offer? Payton Williams couldn't do it.
Your Honor, the government would characterize the conversations between Ms. Payton Williams and Ms. Panarello as preliminary ones to consider whether there was some appetite on the part of Ms. Panarello to explore that conversation.
I think that is such a stretch. I mean, think about this. If Libby had done what Payton Williams thought he was supposed to do, that is deliver the message that if you'll drop the suit, we'll reconsider the termination. He doesn't do that. Payton Williams says to Panarello, well, you were supposed to be given this offer. That's not an offer because she has no authority to do it. And Panarello says, I'm not interested in that. That's all the record shows about the offer.
Yes, Your Honor. And in addition to that, which you've identified in the record, that factual circumstance is slightly different from the circumstances presented in the Knox decision, which the record that was developed there was that the employee and the employer had come to an agreement about a way to handle a proposed disciplinary path for that employee after they reached that agreement, which at the time did not include a waiver of Title VII claims. That employee then makes a charge about disparate treatment in the manner in which the employee, or the employer rather, was meting out certain discipline to its employees on the basis of race. After that charge is made, then the employer adds to the last chance agreement the waiver of the Title VII claims. So even if we accepted for purposes of the argument that the Park Police had tendered an offer by somebody with authority to bind the Park Police in the circumstance, the sequence of that is dissimilar from the manner in which the waiver was added in Knox.
What about the argument made by your friend on the other side that the last chance agreement was anomalous because it didn't have other characteristics that last chance agreements normally have? It only had the waiver.
Your Honor, the government's argument is that because the conversations of exploring the prospect of this global settlement were only very preliminary, there is no evidentiary record to suggest what else would have been included in that last chance agreement. So the record has not been developed because of the fact that Ms. Panarello did not otherwise seek to explore the prospect once she heard that she would have to drop her existing Title VII claims. The conversations ended there, so the record is not developed as to what the contents are. But given that, as the non-movement, Ms. Panarello has to show there's a triable fact as to pretext. Any gaps in the federal or in the evidence there wouldn't support denial of the summary judgment motion, particularly when there's testimony in the case suggesting that the inclusion of last chance agreement within last chance agreements waivers of then existing claims is not anomalous in the circumstance, nor something that was disparately offered to Ms. Panarello either because of her sex or prior protected activity.
But aren't your previous comments supportive of Judge Henderson's point that she doesn't have any burden absent proof that the offer was extended by someone who had authority to extend it? I mean, she doesn't have any burden. I thought that, I'm saying things Judge Henderson hasn't said, but isn't that where some of her questions lead you? You're acting as though the plaintiff hasn't met her burden of proof, yet she didn't have any burden of proof if the offer was never extended. That's all.
Your Honor, I'm not quite sure I follow the question as to which step of the analysis Ms. Panarello would be.
If you can't understand, I won't repeat it. I won't take up your time. Why don't you continue your argument?
As previously mentioned, on this factual record, we believe that the evidence developed is dissimilar from the cases that Ms. Panarello relies on. I've already discussed the distinctions between this case and Knox, but just to briefly discuss the Cognis Corp case, in that case, the court found as potentially retaliatory the fact that the employer had written the waiver in such a manner that it would have required the employee to waive future Title VII claims that had not yet materialized. And that court had included language about the fact that that employers may not buy a license to discriminate through a prospective waiver. Here, the only testimony developed, assuming an offer in the last chance agreement had been made, was that it would require Ms. Panarello to drop then existing Title VII claims. So that's a reason for finding Cognis Corp distinct from this case. And the Board of Governors decision involved a case where the employees would have been forced to choose between waiving statutory rights to file a charge with the EEO as distinct from bringing a Title VII claim, or forego a collectively bargained for contractual right to a grievance procedure. Again, no evidence has been adduced that such a circumstance exists here. And unless there are any other further questions from the panel, we would respectfully request that the decision below be affirmed.
All right, thank you. Madam Clerk, why don't you give Ms. Bertrand 2 minutes?
Thank you. One thing the court just mentioned that I think is really important here is where the burdens are. And this case was a summary judgment determination. This wasn't a trial. This was a summary judgment determination. And on de novo, all we're looking for are there disputes of fact here that support Ms. Panarello's claim that her firing for an off-duty DUI in which she was cooperative, presented no problem, certainly honest, constituted retaliation. And the strongest evidence of that is that she was fired. She was offered a last chance agreement by an agent of the agency, that would be Ms. Peyton Williams, and then was fired when she rejected that. We have other evidence of retaliation that goes to all of this that's being proffered by the government being pretext for what was really going on here. And we have the evidence of sworn statements of people involved in the investigation saying the firing of Ms. Panarello was consistent with this agency's pattern and practice of using the disciplinary process to punish people who come forward in EEO matters. That is per se retaliation. And here, the issue is only, are there issues of fact? And this record, particularly just looking at the little piece of the record here that we're talking about regarding who had authority and what was extended to Ms. Panarello and what did she reject versus accept, are issues of fact. This case must be returned to the district court because these are issues of fact that remain in the province of a jury. Does the court have any further questions for me at this time before, in the last 10 seconds here?
It doesn't look like it. So thank you for your argument. And Madam Clerk, if you would call the next case. Oh, gee.
Case number 22-5140 et al. Campaign Legal Center versus Federal Election Commission, Heritage Action for America, appellant. Mr. Lucas for the appellant, Ms. Donahue for the appellate.
Good morning, Your Honors, and may it please the court. Brenton
Mr. Lucas, okay, I didn't see you at first. Good morning, please proceed.
And may it please the court. Brenton Lucas for Appellant's Heritage Action. I'd like to reserve 2 minutes of my time for rebuttal. 3 days after the district court entered final judgment, authorizing a citizen suit against my client on the premise that the FEC had failed to act on an administrative complaint, the FEC revealed that it had in fact acted on that complaint over a year earlier. In light of this new evidence, we promptly moved to intervene 4 days later. The district court nevertheless denied our motion as untimely. That ruling cannot stand for a number of reasons, 2 of which I'd like to focus my time on today. First, Heritage Action could not have intervened before then. Under Rule 24C, we had to explain to the district court what defense we were going to raise if we were allowed into the proceedings. And until we had evidence that the FEC had in fact acted on the complaint, we could not have advanced a meaningful defense in this failure to act challenge. Second, the timing of the intervention motion here could not have prejudiced CLC. Discovery of the FEC's action in this failure to act case went straight to the district court's subject matter jurisdiction, meaning it had to consider this issue regardless of whether, even if we had never intervened. So this court should reverse the intervention ruling and vacate the orders authorizing the citizen suit. I welcome any questions you may have.
The defense that you present, can it be presented in the citizen suit?
Yes, Your Honor, I'd like to say 2 points about that. First, we believe, like Judge Kelly below, that we can present that in the citizen suit.
So
But-
where's your prejudice? And aren't we reviewing this for abuse of discretion?
Yes, Judge Wilkins, and can I say 2 points on why we're prejudiced here with respect to that? First, CLC has adamantly contested that we cannot raise this argument in front of the citizen suit court. We disagree with that. We think we can, but the risk that the citizen suit court will agree with CLC prompted us to file this appeal. And secondly, even if we set that problem aside, the risks here in front of the citizen suit court are greater than they would be in the authorization court. And let me explain you exactly why. If we go to the citizen suit court and litigate this issue and lose, then we could be subjected to months or even years of discovery before we get a chance to appeal. Conversely, if this court vacates the authorization orders and send this back to Judge Kelly, who authorized the citizen suit, and say if we lose there on this issue, we can appeal directly to this court. So for those 2 reasons, we think we're prejudiced if we're denied our motion to intervene. So turning to the timing of our motion, I just like to point out that CLC never explains how exactly we could have defended against its failure to act case until we had evidence that the FEC had in fact acted. At most, CLC suggests that we should have intervened earlier, accused the FEC of concealing evidence, and then sought discovery. But that wouldn't have worked for a number of reasons. For starters, we think it's almost certain that the district court would not have allowed us to intervene to conduct what it would view as a fishing expedition into a defaulting party. The court had the same information that we did throughout this case, and it believed to the end that the FEC had completely failed to take action on the complaint. And even if the court had let us in to conduct discovery into the FEC had never appeared, and it certainly wasn't going to respond to any discovery requests.
The party doesn't have to appear to respond to a discovery request, can issue a subpoena to third parties. You can certainly, you can certainly issue a subpoena or discovery request to a party who hasn't appeared.
That's true, Your Honor, but there was no indication, and frankly, we don't think the FEC would have responded here. I mean, the FEC didn't even respond.
What do you mean they wouldn't have responded? If you propound a discovery request and a non-party or a party doesn't respond, you file a motion to compel when you get a court order forcing them to respond.
Right, Your Honor. And 2 points. One, it was far from clear that the district court would have issued a motion to compel. And even if it had, we don't think
come on. Your argument is that you don't think that the district court would have done its job in enforcing discovery?
Well, secondly, Your Honor, even if it did, we don't think the FEC, and this is more fundamental, would have responded. When Judge Kelly ordered the FEC to conform to its order, it did nothing. So we don't see why it would have conformed or to a motion to compel the discovery request. So I think going in and trying to
what order are you talking about that they didn't respond to?
So on March 25th of 2022, Judge Kelly said the FEC has failed to act. We order you to conform to this court's order by acting on the complaint. You have 30 days to do so. The FEC didn't show up. It didn't say anything and just completely let that stood by. So we don't see why it would respond.
That's a different process, though, as far as like how that is dealt with when an agency doesn't take an administrative action within a deadline versus when it's got a court order to produce certain records and it doesn't produce them. Okay, fine, they could not produce them if they if they choose to act that way. But then there's contempt and there's fines and there's all sorts of other things that are at the district court's disposal.
So, Your Honor, even if you disagree with those points, I would just like to underscore that really we think the burden should not be placed on parties to affirmatively go in and try and ferret out evidence that a federal agency has been concealing from the courts. And that was particularly clear in our case, because just to emphasize, our client was under consideration by a federal agency whether it was going to launch an investigation into our client. It didn't want to start engaging in adversarial litigation against an agency currently investigating it by prompting motions to compel or trying to seek sanctions against a party that had never appeared. So I think it would really put litigants between a rock and a hard place if you conditioned intervention, the ability to get into court, by saying you have to come in and launch a discovery campaign adversarial to one of the parties that's currently deciding whether to take enforcement action against you. I think that would be a particularly bad rule in terms of setting incentives for parties to come in and, in order to preserve their rights, have to engage in controversy and adversarial relationship. Judge Wilkins, I believe you were on mute. I didn't hear the question.
Oh, ignore that. Go ahead.
Oh, okay. I see I'm getting into my rebuttal time. If the court has any further questions, I'm happy to address them now, or we can pick up the discussion on rebuttal.
All right. Thank you. We'll hear then from Ms. Danahy.
Good morning, Your Honors, and may it please the court. Molly Danahy for the Appellee Campaign Legal Center. The district court did not abuse its discretion in denying Heritage Action's post-judgment motion to intervene as untimely. Campaign Legal Center filed this lawsuit in February 2021. 61 days later, it became clear that the FEC was not going to appear and defend the lawsuit. At that point, it was also clear that Heritage Action's interests, which the district court found to be obviously implicated in this case, would not be represented. Yet Heritage Action waited 11 months until after the district court entered judgment against the FEC to make any effort to protect its interests. And it did so not by moving to intervene, but instead by starting to gather evidence in an attempt to refute CLC's claim. When Heritage Action finally did move to intervene, over a year after the FEC failed to appear and after the case was terminated, its sole purpose was to present argument and evidence that could have been presented to the court before judgment was issued. The court did not abuse its discretion in finding that allowing intervention at this late date and for this—
How could they have presented the evidence to the court before the judgment was issued if they didn't have it?
Well, Your Honor, the evidence that Heritage Action is relying on was available before the FEC failed to appear. There was nothing prevented Heritage Action from taking any steps as soon as it became clear that their interests would not be represented from seeking to obtain that information. And importantly, there was no change in information that was available to Heritage Action about whether the FEC had taken any steps with regard to the administrative complaint. There's no change in the information that was available to them when the FEC failed to appear and when the district court entered a default judgment. The only thing that spurred Heritage Action to attempt to protect its interests in this case was the threat of an adverse judgment and a citizen suit against them. But that threat existed from the inception of the case and from the moment that the FEC failed to appear.
Well, your friend on the other side says that they couldn't appear earlier because in order to be granted intervention, they would have had to articulate what their defense was, and they would have had no good faith basis to articulate the defense that the FEC had acted until they got the documents. So do you agree that they would have had to been able to articulate their defense at the time they requested intervention.
Your Honor, I agree that a defendant or an intervener defendant has to be able to articulate a good faith defense, but I don't believe it was impossible for them to do so at the time that the FEC failed to appear. Campaign Legal filed a motion for default judgment, and under the standard that applies for default against the government, we had to present sufficient evidence for the government to find in our favor and find against, or for the district court to find in our favor and find against the FEC. That the evidence that we presented goes to an 11-factor test that's been set out by this court. Nothing prevented Heritage Action from disputing any of those factors based on the same publicly available evidence that CLC relied on when it filed its motion for default judgment. The particular defense that they have asserted now post-judgment was also available to them at that time. And if Heritage Action had acted diligently and filed a FOIA request on day 61 instead of 11 months later, they would have had the information that they're now relying on in time to contest CLC's motion for default judgment. Even if they didn't intervene and seek discovery, they had the same options available to them at the time that the FEC failed to appear that they did when the district court entered default judgment. And again, there was no change in information available to Heritage Action about the FEC's handling of the administrative case from day 61 to the date 11 months later when they finally filed their FOIA request. And they also didn't make any effort to move for intervention after the default judgment was entered. They simply waited too long. And in particular, the evidence that was available to them when the FEC failed to appear was that there were not 4 votes to defend the lawsuit. That's the statutory threshold that applies for the FEC to appear and defend a lawsuit like the one that CLC brought. That was sufficient evidence to put Heritage Action on notice that there may not have been 4 votes to find reason to believe that there may have also been a deadlock, in other words, over the merits of the case. And I think that's the information that was available to Heritage Action when the FEC failed to appear, and it's the same information that was available to them 11 months later when they finally filed their FOIA request, and over a year after the FEC's failure to appear when they finally moved to intervene.
But do you contest the argument that in terms of the strength of their motion, it would not have had the same force unless somehow a prospective intervener under 24A had first to file a FOIA request?
No, Your Honor. I think the test is whether Heritage Action moved to intervene as soon as it became clear that their interests would be implicated in the case, not as soon as they...
But what I'm getting at is you can file a motion and a request, but why would you do that when the grounds are fairly, I'll just say weak? Because the response would be, well, CDC may appeal. All kinds of things may happen.
Well, Your Honor, our position is that it was fairly clear that the FEC would not appeal this case when it defaulted and didn't appear to defend the case in the district court. And I would also note that...
Well, what do you take of Judge Wilkins' questions in that regard?
With respect to the evidence that was available to Heritage Action at that time?
You heard Judge Wilkins' questions. Okay, I'm not going to repeat it because counsel says they don't understand my questions.
I apologize. My Campaign Legal's position is that the Heritage Action's failure to obtain evidence was due to its own lack of diligence.
Yeah.
If they intended to defend this lawsuit, the time and opportunity to do that was when CLC's motion for default judgment was pending against the FEC, which again...
Been granted.
Well, it was not granted for 10 months after it was filed. There was a period after the FEC failed to appear and defend the case, and after CLC filed its motion for default judgment, when Heritage Action could have intervened, contested any of the factual bases that CLC relied on in its motion for default judgment, or attempted to obtain evidence and present that to the district court before it entered judgment against the FEC. And it simply failed to do so. And that's why it was not an abuse of discretion for the district court to find their motion to intervene to be untimely.
Do you see any difference between a 24A motion and something that might arise under 24B?
Well, Your Honor, I think the timeliness factor is relevant to both motions. And so
I agree, relevant, but that wasn't the question. One is a right to intervene. The other is the court may allow you to intervene.
Yes, Your Honor. And the court may have allowed Heritage Action to intervene under the permissive standard had it moved in a timely fashion. And the reason that the motion for intervention was denied is because it was untimely, and that was not an abuse of discretion on the record before the district court.
Well, I guess what I'm trying to get at, where the smoking gun isn't available to you unless you file an independent administrative action. Does that make any difference when you're talking about 24A? And your answer may be no, but
I don't believe it does, because the test is not, do you have the evidence necessary to defend your claim? It's, did you move to intervene at the time that it became clear that your interests were implicated and would not be represented by any party in the case?
I mean, it seems like the appellant in their argument said that, well, in order to successfully intervene, we would have had to articulate what our defense would be. And I don't see that, actually, I don't see that argument made in their opening brief. And I don't see that standard appearing anywhere in our case law on how to decide whether intervention is appropriate, either whether as intervention as a right or discretionary intervention. But you tell me what you think about those points.
Well, Your Honor, I think I agree that the test is not whether the party has sufficient evidence to intervene, it's whether they've intervened in a timely fashion. And I think it's also a little bit of a red herring here, because the evidence that Heritage Action had when it finally moved to intervene, and the evidence that it had at the time the FEC failed to appear, was nominally the same. All they had at the time they intervened was an acknowledgement from the FEC that it had records responsive to the FOIA request. They didn't have any other additional evidence at that time.
Thank you.
Thank you, Your Honors.
All right, if there are no more questions, then thank you, counsel. And I believe Mr. Lucas has at least 2 minutes remaining.
Thank you, Your Honor. I'd just like to make 3 points. First, I think as this court's colloquy with my friend on the other side has revealed, essentially CLC's position is that we needed and we have the responsibility to file a FOIA request in order to intervene, that was a condition on our intervention, that we had to start ferreting out whether a federal agency, which is presumed to engage and behave in good faith, was concealing material evidence from a court. We think that would be very problematic precedent to set here. And we don't think this
seems like the first hurdle you need to overcome, though, is you're presenting this as if you couldn't have moved earlier because you needed to know what the agency did in order to intervene. And I actually don't see that argument really in your briefing, at least your opening brief. I don't see it. But more importantly, I don't see how that's consistent with the case law and the 4-factor standard that's used to determine whether intervention is appropriate.
A couple points, Your Honor. I think first, with respect to preservation, I think it is in our opening brief. I think we made clear that trying to intervene at that point would have just been a futile gesture, and that wasn't going to come in. And I think more substantively, the fact of the matter is, right, Rule 24C does require us to state what defense we need to come in, and whether or not that's discussed within this court's 4 factors, I think it's quite clear that you shouldn't penalize a party for trying to intervene simply because they don't have a defense at that time. And so I think that's what I would say to that question. But just turning on to my couple other points. Secondly, as my friend on the other side said a lot that we should have just intervened to, engage and fight them. I see I'm out of time. May I have leave to?
Yes, please. Yeah.
To fight them on this 11-factor test. And I could understand her argument if we were now trying to intervene to present argument on that 11-factor test. But what we're doing here, the argument we want to make is that you don't even need to get to that 11-factor test because the FEC actually acted on the complaint. So I don't think that point works. And finally, Your Honors, I would just stress, we're here, we would like the chance to make our arguments in some court, to give this evidence, to provide it and say why this was problematic, why a citizen suit should not be brought against us. We would prefer for the resolution to be in front of the authorizing court below for the reasons I've explained. But if this court were to make clear that we could raise that argument in front of the citizen suit court and that we are not precluded from doing so, that would go a long way to solving our concerns. This court has no further questions. Thank you.
All right. Thank you, counsel. Madam Clerk, would you call the next case?
Case number 22-1107 et al. American Public Gas Association petitioner versus United States Department of Energy. Mr. Day for the Spire petitioners, Mr. Neal for the petitioner Air Conditioning, Heating, and Refrigeration Institute, Mr. Starcher for the respondent.
All right, Mr. Day, good morning.
Good morning. May it please the court, Barton Day for petitioners. I'll be addressing the substantive reasons why the court should set aside the standards at issue. My co-counsel will then address our procedural arguments and the reasons why vacatur is warranted. I'd like to reserve 4 minutes of my time for rebuttal. Petitioners challenge DOE's determination that the standards for commercial package boilers are economically justified. That determination must be supported by clear and convincing evidence, and it was based expressly on the results of life cycle cost analyses indicating that the standards would provide economic benefits for purchasers. Those claimed benefits were very small. For what is by far the largest category of products covered by the standards, DOE claimed average life cycle cost savings that barely exceed 0.1%. Moreover, for this category of products, DOE's numbers show that the majority of all investments in standards compliant boilers are bad economic investments that would leave purchasers in the red, often by thousands of dollars, even after the entire projected 24.8-year life of the product. In fact, DOE's numbers show that significantly more purchasers would suffer net costs as a result of the standard than would benefit from it. Nevertheless, DOE concluded that purchasers would benefit economically if standards forced them to make the 23% of potential investments in standards compliant boilers that they're currently declining in the absence of standards. DOE reached that surprising conclusion because it concluded that there's a small percentage, a relatively small percentage of potential investments that have very high benefits, benefits that in some cases exceed $50,000 on products that have a total installed cost that average less than $30,000. Still, DOE's analysis only generated benefits because it assumed that the probability that purchasers would turn down these highly beneficial investments is exactly the same as the probability that they would decline the very worst investments, including investments that would take more than 900 years to pay off just in simple payback terms. There are three substantive issues concerning DOE's analysis. First, DOE based its analysis on overstated natural gas prices. Second, there are trial cases with unreasonably high burner operating hours, which indicates that the benefits in some of these very high benefit cases are artificially high. Third, DOE's analysis was based on a random assignment methodology that unreasonably assumes that in the absence of standards, purchasers of commercial boilers have literally no tendency at all to make good investments or turn down bad investments, no matter what the economic stakes are. On review of the rule, this court found that DOE failed to address serious concerns raised by all three of those issues. On remand, DOE again failed to address those issues. It still relies on overstated natural gas prices, most obviously because it failed to account for the lower prices paid by very large consumers. Second, its analysis is still distorted by artificially high benefits in cases with unrealistically high burner operating hours. Most importantly, DOE failed to address the basic concern that random assignment overstates the standards to overstates the potential for standards to provide economic benefits for consumers while understating their potential to impose net costs. All three of these issues warrant vacator. Well, I'll be happy to answer any questions concerning any of these issues. I'd like to focus on random assignment.
Can you hear me?
Yes.
Can you just address, I think, kind of factual record type issue that I'm trying to get to the bottom of on this burner operating hour point? And that is the 30 BTUs per hour rule of thumb. The respondent seems to claim in their brief, we'll hear more from them in a moment, that that number did not just come from the sources that were cited in the 2020 rule, I think at footnotes 41 and 42, but that it seems that they're implying that that number was validated by actual utility bill data, but it's not clear to me whether that's the case or not. Can you help elucidate that for me?
Yeah, I don't think that the assumption is just an assumption. DOE claims it lines up with its numbers, but it claims a lot of things that it doesn't really explain a basis for. The 30 BTU per hour as a universal assumption was panned by commenters on the grounds that it makes no logical sense to have one assumption that applies in all cases. It's not a one-size-fits-all kind of issue. The number is high, and most importantly, the fundamental concern was that when you use that assumption, you end up with trial cases with burner operating hours that are way too high to be realistic. And that indicates that in those trial cases, benefits are overstated. And the examples of that are cases, again, pointed out in the reply brief, where 40% of DOE's total benefits are in cases where they assume boilers are operating 24 hours a day, 7 days a week, for more than 7 months out of the year. And the nature of these products is such that, they have to be able to meet peak demand so that they would never be operating continuously for that long period of time. So regardless of where DOE says that particular assumption came from, the assumption was challenged as unreasonable. And most importantly, it was the results that came out of that assumption. The DOE's work based on that assumption produced unreasonable operating conditions and apparently inflated benefits.
I mean, I'll hear from the agency about this, but
I'm sorry, I missed the beginning. I got the.
I'll ask the agency this question, but I didn't see any explanation about the 30 BTU per hour number in the supplemental submission by the agency. Was there anything said about it or not?
No, they didn't even refer to it. Well, they may have mentioned it, but they didn't really say anything substantively about it.
All right.
And that's the problem on remand, is that they talked about their methodology, but they didn't answer the questions. And in that case, the fundamental question was, whatever you're doing here, you're generating these trial cases that appear to be artificially inflated. And of course, with random assignment, it's those high extreme economic outcomes that drive the results of the analysis.
All right. I don't want to take up more of your time.
Thank you. I would like to focus on random assignment. I think the principal issues there are that DOE's numbers show that more consumers, more purchasers would suffer net costs as a result of the standards than would benefit from. And the only reason they show benefits is because they assume that purchasers never consider the economics of potential investments, regardless of the stakes involved. That's an absurd assumption, and DOE has never even claimed that it's valid. Their explanation didn't even address the concerns about the absurd impacts of random assignment, particularly random assignment of these very high economic consequence trial cases, good or bad.
Actually,
and so the
record
response
shows,
was
counsel, that the agency on remand
Mr. Day,
consider.
my
the
colleague has a
factors.
question. Go ahead.
All right. So to say that they never even considered it is just inaccurate. You may disagree with its conclusion, but it did consider it. It addressed it.
It never addressed the concern about the random assignment of very high consequence trial cases. It simply it talked about market failures that don't even remotely justify the random assignment of trial cases, for example, where the more efficient product actually costs less to install. So there's no rationale to say a standard is necessary to force consumers to make those investments. And yet, despite the abstract arguments that those cases don't exist in this context, DOE's numbers show that they claim benefits for such cases. So they never even, that was an issue that was raised right from the get-go. It's one of the most, it's been one of the most controversial issues in standards rulemaking for 7 years now. And DOE didn't even mention it. They simply said, well, you know, there are market failures and therefore purchasers don't make perfect economic decisions. And the conclusion that consumers don't always make perfect economic decisions based on a detailed economic analysis is no basis at all to conclude that purchasers literally never consider the economics of potential
Counsel, I
efficiency
think you're
concerns.
you're building a straw man to knock it down. I think that Judge Rogers' point is that, and it's in the briefing, is that they did present evidence that showed that there was not always correlation between the purchasing decisions and the efficiency kind of economic impact of those decisions. I think there were like 3 separate studies that were presented that demonstrated that fact. Am I wrong about that?
There are a variety of things that I could say in response to that. One is that I don't think their studies say what they say what DOE says they say, but putting that aside, even if you assume that all of DOE's factual arguments are valid, DOE's conclusion is consumers don't always make perfect economic decisions based on a detailed economic analysis. And that is no basis at all for random assignment of trial cases where the more efficient product costs less. There's no rationale for assigning cases like that randomly, and yet DOE did. If you want to understand this, I would refer you to the figure on page 32 of our opening brief, which shows the entire distribution of, and these are DOE's trial cases. So these are DOE's own numbers. And what they show is, first you have to ignore that long flat line in the middle because those aren't real results. They're just zeros ostensibly representing the 77% of potential investments consumers would make on their own. But if you look at the extreme ends, which is where all the action is, you see that there are a lot of bad outcomes depicted on the left side of that figure. And there are a couple of cases there where the payback period in simple payback terms is over 900 years. So over 900 years just to break even. What's remarkable is not that there are 2 of those cases out there. What's remarkable is that DOE literally assumed that 77% of the purchasers that face those kinds of investments make the investment anyway. That's exactly the same percentage as they assume would make the very best investment. And on the other end of that scale, you can see that there are 84 individual trial cases that account for all of the benefits necessary to put the average above 0. And those 84 cases have benefits of the range goes up to over $70,000. And those cases are there because DOE assumed that the probability that purchasers acting on their own would turn down those highly beneficial investments is exactly the same as the probability that they would decline an investment with a 900-year payback period. That assumption is ludicrous. And there isn't any market failure that can explain that. And I can go through and, if you'd like, I can give you a 3-minute tour of why DOE's market failure arguments make no sense. But I think it's pretty clear on its face when you look at the results of DOE's analysis. They're basically saying, okay, most of these investments are bad. In fact, over 60%, according to DOE's numbers, impose net costs, with most of those imposing net costs in excess of $1,000 even after 24.8 years. And yet, because of this small percentage of highly beneficial investments, we're going to claim that there are net benefits. And that only works because DOE assumes that even in those very extreme cases, there's no statistical difference in the probability that purchasers will make or decline those investments, which is absolutely ridiculous.
Judge Wilkins.
I see I'm out of time and I didn't want to reserve time for rebuttal. I want to respond to any
Mr. Day,
questions. Yeah,
would you
yes.
please wait? You keep interrupting us. Judge
Oh, I'm
Wilkins.
sorry. I'm not hearing perhaps.
All right. Well, Judge Wilkins, have you had your question answered?
Yes, I have.
All right, Judge Rogers.
I'm fine.
Okay, you're fine. All right, Mr. Day, you have used your rebuttal time, and we will perhaps give you 2 minutes, notwithstanding that. We'll now hear from Mr. Neal.
Thank you.
May it please the court, Jason Neal for petitioners. I'd like to make 3 main points about the procedural issue here and the appropriate remedy in this case. First, DOE's argument that the final rule was a mere supplement, not requiring notice and comment on the agency's first ever evidence regarding actual market failures in this market, is contrary to Chamber of Commerce against SEC. Second, DOE's backup position that complying with this court's deadline on remand required DOE to skip notice and comment is also untenable. Third, the substantive issues and the procedural issues here require vacatur. In APGA 1, the court previously declined to vacate because DOE promised a full and sound explanation on remand. DOE's failure to provide such an explanation here demonstrates that it does not have one and that the rule should be vacated. DOE's primary justification in the final rule for its refusal of notice and comment was that this court remanded without vacatur and that the final rule is merely a supplement providing further explanation. The first part of that justification is irrelevant. Chamber of Commerce explains that notice and comment requirements still apply on remand. The second part of the answer distorts both the law and the facts here. As the court explained in Chamber of Commerce, the exception to notice and comment is for information that merely supplements information or data already in the rulemaking record. The final rule says that it supplements DOE's conclusions that market failures apply, but supplementing data or evidence is very different from supplementing a conclusion that the court already said was unsupported. DOE claims in its brief that the 2020 rule advanced a hypothesis and some supporting explanation, quoting in part from Building Industry Association, but DOE cuts off the quote. The court in Building Industry Association said that the agency's proposal, quote, advanced for comment a hypothesis and some supporting data. Here, the notice of proposed rulemaking did not justify random assignment based on market failures, and the 2020 rule didn't either, except as an attack on the supposed alternative of assuming perfect rationality on behalf of all purchasers. Even there, the 2020 rule did so only in a conclusory and unsupported way, as the court found in the last appeal. There was no evidence to supplement here. DOE also claims that it had good cause to skip notice and comment because of the court's 90-day deadline. Again, DOE is wrong on both the facts and the law. On the facts, DOE's complaint that 90 days would be insufficient for notice and comment is wrong and beside the point. It is wrong because DOE already knew, at least as early as oral argument in APGA 1, that the court was interested in evidence of market failures, given DOE's invocation of those market failures at oral argument. DOE could easily have published a request for comment, providing notice of its market failure evidence and supporting data in time to meet the court's deadline. DOE's argument here is beside the point because the court anticipated the potential need for more time by giving DOE 10 days to demonstrate such a need. DOE declined that opportunity and did not seek any other relief that would give it more time. I think it's important to take a step back and remember how we got here. DOE urged the court not to vacate the rule by promising a full and sound explanation on remand. If DOE thought that it needed more time for a more substantive reconsideration of the rule, it shouldn't have made that representation to the court. But it did. And if DOE knew that it planned to rely on evidence of market failures, which it brought up at oral argument, it should and could have done so in compliance with the APA. And we know from the certified index to the record, and we know from the final rule, that as soon as 2 days after the court released its opinion, DOE was collecting evidence of market failures for it to use. On the law here—
Mr. Neal, what do you think about DOE naming this a supplement as opposed to an amended rule, a revised rule, and the title actually has a long description of in response to the DC Circuit's direction. I don't know that I've seen that before. Have you?
I'm not sure, Your Honor. I do believe in the Federal Register. It does still say final rule here. I could go look and check to be sure on
I don't
rebuttal.
think it does. I think it's called a supplement, but
Okay.
because I think we looked at that.
I will go back and see if
What
check my
I'll
math
tell you
on-
what I'm concerned with your, well, I am concerned that your argument raises a point that this court in the first case, in good faith, assumed that this would be not a ministerial remand, but that it would be simply to make a fuller record and that the explanation was in the record. It just wasn't, I mean, it was gathered, it just wasn't in the record. And your argument and the argument of your colleague is that they added all sorts of things, new evidence, new arguments, new claims, and so forth, and that you are entitled to notice and comment. And in that regard, can you expand a little bit on the prejudice that you suffer without the notice and comment, because you've got that burden?
Sure, Your Honor. Let me take those in order. So I'll start with the importance of this being labeled a supplement. I think Chamber of Commerce says when a court remands without vacater, notice and comment requirements still apply. Second, to your question about was this just an explanation, I think you only need to look at the final rule. DOE admits that it collected new data and new evidence to justify the market failures that it had invoked. APGA 1 said there was no evidence of those market failures. I think the court was right there. Perhaps in theory, DOE could have just written a supplemental explanation to try to address the court's concerns. I don't think it could have done that in a sufficient way that would have addressed the substantive problems, but procedurally, perhaps it could have just written something. But that's not what it did. It provided explanation based on new economic literature that it had talked about at oral argument, and it collected new data that Judge Wilkins, you asked about. But it never provided an opportunity for us to comment on that in the record. And that brings me, I think, Judge Henderson, to your last question about prejudice. We did our level best in the March 2022 filing to anticipate the issues that we thought DOE was going to address on remand because it hadn't put anything out for public comment. I think the issues that we raised there were significant, and DOE never mentioned them in the final rule. I think that itself is sufficient to establish prejudice. But the bar for prejudice under Chamber of Commerce is quite low. I think it's that we have something useful to say, not that we would have changed the outcome of what the agency did. We had something useful to say in the March 2022 request, and we would have had more to say if DOE had made public its evidence and given us a chance to comment on it. I know I'm in my rebuttal time, so I'd like to stop there and save a minute if I can, but I'm happy to answer any further questions.
All right, Judge Wilkins, do you have any questions?
No.
Okay, Judge Rogers?
No, I'm okay.
Okay. Then thank you, Mr. Neal. We'll give you some time in rebuttal. Mr. Starcher.
Good morning, Your Honors, and may it please the court. Jack Starcher on behalf of the United States Department of Energy. I'd like to start with just addressing a few representations made in connection with the random assignment, which has been sort of I guess the lead argument sort of throughout this case. And I just wanted to address two specific representations before questionings take us away from it that are inaccurate and need to be addressed from the other side. First is this suggestion by opposing counsel that there's something suspect or surprising about the fact that the Department of Energy didn't specifically respond to their argument about the fact that there may be some boilers for which the cost of installing that boiler on day one, the more efficient boiler would have been the lowest cost option. There's a reason that the rule doesn't respond to that point, and the reason is that that argument was never raised during notice and comment rulemaking. As we note in our brief, that argument came up only one time in a footnote to a single submission, and it wasn't made as an argument. It was just a reference to a study made in a different rulemaking involving different kinds of boilers. And in the reply brief, petitioners identify under 50, I think it's 46 maybe, applications for one of the smaller subclasses of boilers, the large gas hot water boilers, for which the more efficient boiler would have been the low cost option at the date of install. But as even petitioners acknowledge in their reply brief, even if you lop off those 46 cases, that represents just about 10% of the total benefits, even for that one set of boilers. And what petitioners don't acknowledge is that the data is available for all of these boiler sets. You can look at it and see that, in fact, for small gas hot water boilers, the largest set of boilers, that's the focus of all the charts that petitioners include in their briefs, there are no cases for which the boiler, the more efficient boiler would have been the cheapest result at install. So this idea that that's somehow concerning or surprising is just inaccurate and obfuscates the fact that that argument was never raised during notice and comment and can't be raised for the first time in a reply brief during the second set of petitions for review. And with that, I want to turn to this recurring theme, both at argument today and in petitioners' briefs, that somehow random assignment, that the modeling decisions used in this model assumed random behavior or assumed that consumers are making certain shocking or surprising decisions at certain rates. As we explain in our brief, this random assignment is a methodological description of an assumption used in the model to try to best reflect complex consumer behavior. It has nothing to do with assuming that individual consumers are behaving randomly. It has nothing to do with assuming that certain outcomes are going to be, certain shocking outcomes are going to be occurring at any specific rate. The whole reason why you use random distribution in a case like this, and this is explained at length, particularly in the supplement, but also referenced in the original rule, is that when you know a lot about a market, as we did here, the department had really good data about the kinds of boilers that were going to be shipped out absent the rule. It had really, really good data about the nature of the buildings that would be installing these boilers absent the rule. And the department also knew a lot about how consumers in this space act, as noted in the supplement, as I guess noted in the rule and then explained in much greater detail in the supplement. Specifically in the realm of energy efficiency investments, we know for a fact, and there's lots of research out there about this, and there's also the studies cited in the supplement, we know for a fact that there are a huge number of factors that go into any individual purchasing decision. And while economic benefit is one of those factors, the ability for consumers to capture economic benefit in this space is complicated. And as we noted in our brief, and petitioners really had no reply to this, even accepting their position that the rule, I guess an opening thesis of their position that that the rule underaccounted for economic benefit to consumers. The problem with that is that even just taking that on its face, what does that mean? As we note in the rule, economic benefit is a conclusion that's the result of quite a complex modeling. Would it be economically beneficial for a consumer to buy a boiler that will produce a couple $100 benefit over a 25-year life of a boiler, if that consumer thinks maybe they won't own and operate the boiler for the entire 25 years? If the purchaser of the boiler owns a residential building where the residents of that building are going to be paying the electricity costs. For all of the reasons that are given in the supplement and also discussed in our brief, petitioner's entire argument on this front really doesn't hold together. And I think the greatest proof of that is in their reply brief, petitioners acknowledge, I think, that really what they wanted the department to do here was to randomly pick some percentage of base cases. In their reply brief, they suggest 20% based on no evidence and no citation. It seems that petitioners just wanted the department to randomly select some subset of boilers and assign those and those alone based on consideration of a single fact, which is economic benefit. But again, as discussed at length in the supplement and in our briefing, consumers aren't making these decisions based on a single fact, and we know that. And we know that not only from economic data, but from case studies that only confirm what the department said in its rulemaking. I also just want to briefly address, and certainly feel free to interrupt if you want to take me in a different direction, but I think another theme in this case is petitioner's suggestion that because of the heightened standard, the heightened evidentiary standard that's at issue with this statute, the clear and convincing evidence standard, that somehow all of this court's case law, and there's a lot of it, making the kind of common sense point that in APA review, agencies are allowed to use models. They're allowed to engage in predictives. They're allowed to use data that is imperfect in certain ways, as long as they explain why the decision to do so is reasonable. Petitioners' arguments all run contrary to that precedent, and the only way that they get there, I think, is by saying that somehow clear and convincing evidence is meaningfully different in that respect.
I guess I would push back on that and direct you to the whole dispute over boiler operating hours. In part of our prior decision, told the agency to explain the 30 BTU per hour assumption. Do you agree that we said for the agency to do that in our prior opinion?
So with in the context of burner operating hours, that the thing that this court identified in its earlier decision, and again, I think it's worth noting that on this issue, the court said it wasn't even clear whether this issue alone was enough to warrant remand independent of the other issues. But this court made clear that the concern, burner operating hours is an output of other factors in the analysis. And this court made clear in its decision that the concern that had been raised by commenters was that certain, and this is still and again, I think petitioners acknowledge that this is still their argument to this day, that certain very high extreme burner operating hours were being produced in a way that should have signaled to the agency that other assumptions that the agency had made were wrong.
Respectfully, counsel, that's not the way that I read our opinion. Our opinion on this burner operating hours issue noted concerns that had been raised by petitioners, and it listed one of them is the adoption of the rule of thumb that for every square foot of heated area, a building uses 30 BTUs per hour. And then we conclude that by saying that section, we expect on remand a reasoned response to these concerns as well.
So the response contained in the supplement is a reasoned response to all of the concerns raised by the court in that section of its opinion, and here's why. As explained in the supplement, all of these figures that we're talking about, so this is the burner operating hours, this is the heating load, this is the representative capacity that was used in estimating burner operating hours. As explained in the supplement, and this is, I think, most clear on JA 525 to 526, all of those figures don't meaningfully alter the actual conclusions that supported the outcome of the rule. And again, to return for kind of a half second to the standard here, remember that the standard, the question for this court is, was it reasonable for the department to conclude that the heightened standards adopted are economically justified? So economic justification is the question here. And economic justification does not turn on every jot and tittle of every subcomponent of the model. As explained in the supplement and also as noted in our brief, there were a number of economic benefits at issue here. The statute didn't require any particular quantum of consumer savings to.
It seems to me, counsel, with respect, what you're saying is that even though the court said we wanted a response to the validity of this 30 BTU per hour heat load assumption, we didn't really have to give you a response to that because we said that that assumption wouldn't have really changed anything, that assumption was really not relevant. And, you know, I don't know, you may or may not be right about that, but when a court tells you to explain something and you don't, and we say that that's part of what needs to be explained, then that seems to me to be a problem.
So again, I guess
Because I don't see any discussion at all of the 30 BTU per hour assumption in the supplement.
I believe that's correct, but again, I guess a two-part answer. Number one,
how can you have a reasoned explanation about something that you don't discuss at all?
in the following way, as this court noted, all of those figures that were that had highlighted the 30 BTU and the assumptions about and the other assumptions that fed into boiler operating hours. As petitioners acknowledge, those figures only affect burner operating hours, or at least for purposes of their argument, are relevant to these burner operating hour figures. The answer is the burner operating hours are not concerning, even with those figures baked into them. And in any event, burner operating hours are not themselves something that feed into the conclusions that matter about the rule. Burner operating hours are primarily a result of the efficiency that was assigned to the building in the model, and all of the data we had about that building. And we had a lot of data. We knew the exact square footage of these buildings that we were assigning models to, and we knew we even had energy consumption estimates for each building. The savings associated with the rule are not attributable to burner operating hours. And the concerns that this court highlighted in connection, and yes, this court mentioned the 30 BTU per hour as part of the burner operating hour problem, but the agency did respond to the burner operating hour problem and explained, as this court directed it to, why those anomalous numbers and why the high burner operating hours that were highlighted by commenters during notice and comment rulemaking were in fact not surprising or concerning. I can get into more technical. I mean, this is all very technical, obviously. I guess just to give a high level, and this is noted in the supplement, these extreme cases that petitioners now really are focusing on, these handful of instances in which the rule produced burner operating hours of 8 months or so for something like 5% of all cases. That's a direct result of the fact that the rule utilized representative capacities for each boiler class. Essentially, each boiler class covers quite a broad range of outputs. So for example, for the small category, it's something from like 300,000 BTUs per hour all the way up to 2.5 million. As a sort of helpful way to simplify things, the rule utilized representative capacities within that range. That's essentially what's producing these really high burner operating hours, but those hours aren't concerning. And if you went into the model and changed things, to the extent you were assigning higher output boilers in order to reduce burner operating hours for the high end, the fuel consumed by those boilers would be the same. And we know the amount of fuel being consumed for each building because we had actual data on that from CBEX and the residential survey data as well. So I guess this is a long way of saying.
So help me understand what work does the 30 BTU per hour assumption do?
It's as I understand it, it's a baseline figure, much like the sort of representative capacity that was used in order to calculate burner operating hours. And again, because burner operating hours weren't an
so you use the 30 BTU per hour number to calculate burner operating hours. Yes,
that's my understanding. Is that both burner operating hours and both this 30 BTU figure.
So then why isn't there some sort of a responsibility then, if burner operating hours is relevant, to explain one of the inputs into the calculation of how you derive the burner operating hour number?
So that's exactly the response. burner operating hours are not relevant. They didn't feed into what the department, and again, I think this is explained on in the supplement on J525, 526. What mattered was savings to consumers, right? Savings to consumers in the form of lower total fuel consumption over the life of the boiler.
Did the first panel believe that burner operating hours were irrelevant?
I don't know if they believed that, but certainly, I mean, the comment.
Did the opinion that they wrote conclude that burner operating hours were irrelevant? I mean, why would they remand it if they thought that it was irrelevant?
So, and I think this is in the original opinion, although this wasn't a focus of earlier petitions, but the comment that was highlighted in the original decision, the specific comment about highlighting anomalous burner operating hours at the, there was this is the one discussed in our brief, and that's discussed at length in the opinion, that, a commenter commented that the median burner operating hours for all classes was over 1,000, et cetera, et cetera, et cetera. Because burner operating hours are not an input, the reason why that mattered is, and I think that the panel noted this in its original decision, the reason why that mattered is because the thesis of that comment and the reason why this panel remanded on that issue was that there was a concern that some of those hours were so unrealistic that it should have flagged for the agency that certain inputs into that figure or certain other parts of the agency's model were wrong or should be reconsidered. And so the top line response is those numbers aren't surprising, and therefore there was no need to go in and reassess any of the figures that fed into burner operating hours, right? The burner operating hours, because they're not an input into economic benefit, could only matter to the extent they raise for the agency a red flag that would in turn cause the agency to go back and reconsider things that fed into that number. And the agency's response, and maybe we've gone full circle and I've given you a much cleaner answer to your question than I have prior. Full circle, the agency's response in the supplement is burner operating hours are not surprising. There's nothing concerning here. And therefore there is no need for us to take the next step and to reevaluate figures that fed into burner operating hours. I think this is clear from the panel's decision, the earlier decision, that burner operating hours were relevant as sort of a red flag problem, right? That something about burner operating hours was so unrealistic or so surprising that the agency should have recognized other problems in its model. And the supplement does.
Thank you. Judge Henderson, I'm just noting that the clock seems to be stuck at 3 minutes and 43 seconds. I don't know if the clerk can address that.
There we go.
There is a connection issue, but I am keeping track of the time.
Okay. Sorry, just got so engrossed in discussion of burner operating hours, I didn't even notice the time had stopped. Thank you for flagging that. I'm happy to respond to any other questions as my time runs down. I want to make sure we there's a lot of, I know a lot of different moving parts in this case. I guess one point that I did just want to make, and this is returning us to the random assignment space, and I just want to make sure to get this out there. Petitioners, another, and they said this was said at argument today that somehow the rule was only economically justified because of some very, very small percentage of very high benefit cases. That simply, you can look at the data on this. DOE has looked at the data, just as sort of a pressure test. For the small gas hot water heaters, the biggest group of boilers that has been spoken about the most today, you can look at the data on this. DOE could have gone in and just ignored all of the highest benefit cases. So, for example, any benefit more than $15,000. You can go in and you can just lop off all of those highest benefit cases, and you still reach the same conclusion. You still show benefit to consumers, which is all the department needed to find. And again, it's not even clear under the statute that it needed to find a benefit to consumers. But the department's conclusion here, which is that this was economically justified, is unchanged, even doing this totally unsupported exercise that petitioners ask the department to do, which is to arbitrarily go in and just lop off some certain number of base cases, even though it's reasonable to think those base cases exist for all of the reasons given in the rule. It simply just it isn't hard to envision. And sorry, the clock.
Yes, finish your sentence.
Thank you. It's simply, for all the reasons given in the supplement, it is not hard at all to believe or to imagine examples of buildings that are in fact leaving huge amounts of savings on the table for all sorts of reasons, and some of them are listed in the supplement. I think, to me, the most intuitive and easy is owner of boiler does not pay gas bills because it's a rental space and someone else is paying the bills. Of course, that person is not going to internalize lower gas bills, and of course, that person is going to, in some cases at least, just buy the cheapest boiler because they don't.
All right, we have your argument. Thank you,
Thank
Mr.
you.
Starcher. Mr. Day, why don't you take 2 minutes?
Thank you. I've got a lot to respond to here. DOE's arguments on burner operating hours are completely invalid. Burner operating hours are energy consumption, which is what drives benefits, divided by the capacity of the boiler. And so if your energy consumption numbers are wrong, your burner operating hour numbers are wrong. Here, the reverse is what we saw visibly, is that the burner operating hours were ridiculous. And so that means that either the capacity is wrong, in which case costs are low, so benefits are exaggerated, or energy consumption is high, and in that case, benefits are exaggerated. Either way, it's a problem. The fact that they don't use burner operating hours to calculate benefits is irrelevant. It's a clear indication of a problem with its analysis. The claim that owners of apartment buildings would, don't pay the fees for boilers is false, and DOE knows it's false. Boilers provide service to the building. You cannot meter them. There is a boiler in the basement. It's not like a furnace where everybody in their apartment has their own furnace. There is a boiler that serves the building. The bill goes to the building, and unless there's one tenant, that bill will never go to a tenant. And that's in the record. And, they make these arguments, but they don't even refer to the fact that the record shows, and this is cited in our brief, that, there are very, very few cases where even the possibility of split incentives exists. And if DOE believed that there are 7% or whatever that they might be able to argue, and they assume that purchasers would go to the low-cost boiler in every one of those cases, what that means is you take 7% of the cases and you assign whatever the low-cost product is, which may or may not be the low-efficiency product. So, the idea that kind of a market failure even remotely justifies random assignment is absolutely invalid. The claim that these issues, particularly the concerns about the random assignment of the cases that drive the results of DOE's analysis, were not raised, is just false. That issue was identified as a problem back in 2016. It was an issue I raised during the discussion with OMB, but when the final rule was in the works, DOE was on the line for that call. They can't claim they did not consider that. The record of that is in the administrative record. It's cited in our brief.
All right, Mr. Day, finish up your argument.
For error correction that discussed the issue.
Mr. Day, finish your sentence.
I'm sorry?
Finish your sentence.
The point is that the issue's been raised over and over again over the last 7 years. It was raised in briefing below. I raised it in oral argument and in briefing. So the idea that this is something that's a Johnny-come-lately issue is just not correct.
All right, thank you. Mr. Neal, why don't you take 2 minutes?
Thank you, Your Honor. I'd just like to make 2 quick points. First, Judge Henderson, to your specific question about whether the final rule is a final rule, JA 517, the left-hand column, the bolded word action says final rule, semicolon, supplemental response to comments. That's what I had in mind in my answer to you. Second, I want to make sure that we discuss vacatur and the appropriate remedy here. And I won't belabor the point, but I'm happy to answer questions. We've been through this process twice now. There's a long rulemaking process. We went up to this court in APGA 1. We identified fundamental defects with the rule that have come up to today, and that the court found that DOE had not adequately considered or explained. I think the final rule shows that the problem in APGA 1 was not that DOE didn't write enough about these issues. It's that its approach doesn't work. And I haven't seen anything in the briefs or in the oral argument today that suggests that DOE is interested in some wholesale reconsideration of that. And so I would urge this court, if you agree with us, you need to vacate the rule, not just remand where the agency can write more words about these things. I think these are issues where if DOE seriously reconsidered the problems that we identified, its analysis would have to run so fundamentally differently that it would be a mistake to leave the rule in place. The rule is harming the industry. It went into effect 10 days ago, and manufacturers were already having to make changes in anticipation of that effective date. Many of them have made significant changes to their operations. They'd love to have the previous rule back, and that's the remedy that we're asking this court to provide.
Well, now, if they've made these changes, how disruptive would it be to put them back where they were before January 10th?
Your Honor, I can't speak to the circumstances of any particular manufacturer because I think it varies from one to the other. But I can say that for at least some manufacturers, they are capable, if this court orders relief, fairly soon, of changing operations back, restarting lines of business that they've started to wind down. This court denied a stay, and so I think that there have been harms that have come to at least some of the manufacturers. But the industry would like to have the old rule back, and I think there would be a real benefit for that. As far as disruptive consequences go, this is just not like other cases this court has discussed where there's some effect of the rule that just can't be unwound. I'd be happy to talk about other cases, but that's the point.
Fine, thank you. Any questions, Judge Wilkins or Judge Rogers?
No, thank you.
No.
All right. Thank you then, Madam Clerk, if you would close us down.
This honorable court is now adjourned until Monday, January 23rd at 9:30 a.m.